All right. Hi, everyone. Good afternoon, and thank you so much for joining our webinar today, which is Proving Grounds, Answer the Call with Effective FMLA Administration. My name is Amanda, and I'll be your moderator today. ERISA attorney Larry Grudzien is our presenter. We're going to cover a lot of valuable information in just an hour, so don't worry if you miss anything. We'll be emailing you a recording and the slides after the webinar concludes. I'm going to keep everyone muted to make sure we don't get any background noise during the webinar, but Larry will pause periodically for questions. Just hit the raise hand button, and I'll unmute you so you can ask. If you don't have a microphone, or if you just prefer typing, you can ask the question in the box below and I'll read it aloud and get the answer for you. Our next webinar will cover all the legislative changes since our previous update. It'll take place on February 7th at 1 p.m. We hope to see you there. For now, I'm going to turn the presentation over to Larry.
Thank you very much. Before we begin, the topic of the hour is what's going to happen to ACA because of Trump getting sworn in and his executive orders. And before I begin this seminar, I just want to let you know, I think over the next 3 to 4 days, it's going to be very important to watch the news and to see exactly, because basically he released on his first day an executive order easing the requirements of the ACA. It's going to take action from the different agencies to put that in action, and I think one of the first casualties of the executive order and action from the various agencies is going to be probably reporting requirements that are going to be due in the next probably month. So stay tuned for this. Don't take any action until you see something official from the IRS, DOL, and HHS, and something will be coming soon. I'm hoping that something will be coming probably in the next 4 to 7 days, and let's see what happens. Okay, so but that's the most recent development. Once Trump's executive order came out, my phone rang off the hook, and that was on a Saturday. So just be forewarned the fact that many aspects of ACA now are in jeopardy, and it looks like to me that the various agencies may grant waivers for a bunch of the requirements. So watch the newspapers. If you have any services, look at them on a daily basis to see if anything is released. Okay, let's go to the matter at hand in family and medical leave. This is complicated because for many businesses, you may not get somebody asking for leave on a regular basis. So every time anybody asks for leave, you have to relearn this area. And there's a ton of requirements, a ton of notice requirements that you have to really adhere to in order to get this right. And there's a lot of rules on this. But one thing is pretty interesting is that DOL has a lot of Q's and A's and a lot of good material on their website in dealing with family and medical leave. So a lot of their stuff is pretty, of any area, I think they've done a really good job. Also, when I mention some of these notice requirements, there are sample notices on the DOL website. So you don't have to reinvent the wheel here. Now, one of the biggest misnomers with family and medical leave is that an employer will come to me and say, well, somebody went on leave and I didn't give them family and medical leave because they didn't ask for it. So since they didn't mention it, I didn't mention it, and that's not the way this works. In determining whether an employee is eligible for family and medical leave is up to the employer. They determine. It's not up to the employee to ask for it. It's the employer to designate the leave as being eligible for family and medical leave. So that's one of the biggest misnomers. And this is important because family and medical leave is extremely important, because if somebody quits working full-time, doesn't work at all, basically in most coverages, medical, that person can continue coverage because they haven't worked the number of hours. So therefore, coverage has to terminate unless you offer them COBRA or they qualify for family and medical leave. So in this situation, that's the only 2 times that coverage can continue. And that's true for workers' comp. I mean, if somebody isn't working, there's only two situations where coverage can continue, and you have to look at the contract or your plan to see when coverage stops after that person doesn't work the number of hours. But I want to try to go through and cover every aspect of this so you know what to get into if an employee approaches you and said, I want to go on leave. And the purpose behind this seminar is to tell you what your responsibilities are when that happens. All right, what do you have to do? So I'll talk about the employer coverage and employee eligibility, qualifying reasons for leave, only certain things do qualify, the amount of leave. Then I'll be talking about what the employer rights and responsibilities are, because when somebody is asked for leave, you have to, again, adhere to the notice requirements, and you can't give leave until somebody satisfies those requirements under family medical leave. And then I have employee rights and responsibilities. Yes, the employer has rights and responsibilities, but so the employee, and if they don't adhere and meet their responsibilities under family medical leave, then as an employer, then that leave is not eligible. Now, the reason why this is extremely important is because of the fact that in this situation, when somebody qualifies for family medical leave, in all essence, they are treated as an ongoing employee. They pay the ongoing employee rate for coverage. They have employment rehire eligibility here. So there's a lot of rights that go into if somebody does qualify for family medical leave. And then lastly, I'll be talking about the military family leave provisions. There are special provisions that were added a few years ago, either when somebody is being deployed or comes back injured, then their family members have certain rights to help them on leave, and the employer has to comply with those requirements. So let's look at this. So which employers have to comply with family medical leave? Well, any private sector employers with 50 or more employees, and that's 50 or more employees and 20 or more work weeks in the current or preceding year. And then public agencies and public and private elementary and secondary schools, and just look and see that the 50 employee requirement doesn't apply to public entities, agencies, or public and private schools. So only the private sector employers is that 50 requirement apply here. So it's extremely important to look at this and when you have to comply with these requirements. Now, employee eligibility, you don't have to give it to everyone. You have to be employed by a covered employer, worked at least 12 months, have at least 1250 hours during the 12 months before the leave begins, and employed at a work site with 50 or more employees, now within 75 miles. So again, you don't have to offer this to part-time employees. You have to work at least 1,250 hours, and if you're an employer that doesn't have a grouping of 50 employees in any work site, then in that situation, then you may, even though you have 50 employees, they're spread out over a large geographic area, you may not have to comply with the rules. Now, you can only be granted family medical leave if you have particular reasons why you want to take leave. So as this slide indicates, you can take leave if it's for the birth or placement of child for adoption or foster care, the care for a son, daughter, spouse, son or daughter, parent. Now, what's interesting here, you don't see grandparents, or you don't see father-in-law or mother-in-law, which is very interesting. Or you can take leave for your own serious, health condition, serious health condition. Now, for military leave, as I indicated before, there are two reasons why you can take leave: because of a qualifying reason arising out of a covered employee status of military member who is employee spouse, and basically what the first one is is you have to take time off because your family member or you are being deployed overseas. And there are a number of reasons, which I will go over when I go through this a little bit later, but it could be for family reasons, it could be for financial reasons, it could be a number of different things that, and again, this is because of deployment. Now, the second reason is to take care of a covered service member with a serious injury or illness, and this applies both to people currently in the military or veterans. So this is to care for a covered service member with a serious illness or injury when the employee is the spouse, son or daughter, parent, or next of kin of the covered service member. So again, you're taking care of somebody who's just come back and because of an injury in the service, you have to take care of them. Now, qualifying family members, parent is biological, adoptive, step, or foster, spouse, husband, or wife, either common law or same-sex, son or daughter for leave other than military, a biological, adopted, or foster child, stepchild, a legal ward, or a child of a person standing in local parentis with either 18 years old or 18 or older. And then for the birth or replacement of a child, and this applies, it can apply both for the father and mother, and the employers may take leave before the actual birth, placement, or adoption. It can be afterwards, but the leave must be completed by the end of the 12-month period beginning on the date of the birth or placement. So again, there's a time limit on when you can take it for that reason. Also, too, for serious health condition, again, it's a serious health condition of yourself or your family member. It includes illness, injury, impairment, or physical or mental condition involving inpatient care, continuing treatment by a healthcare provider, overnight stay in a hospital, hospice, or residence, including a related incapacity or subsequent treatment, continuing treatment by a healthcare provider, incapacity, pregnancy, chronic conditions, permanent or long-term conditions, and absence to receive multiple treatments. And continuing care is very important because where this comes up is if someone who has cancer or a long-standing condition and they want to take time off for treatments, this is where it comes into. It's not something that's immediate. It's something that could be chronic and ongoing that they have to take time off, and you have to allow them time to get treatment. So incapacity plus treatment, incapacitate more than 3 days, and this question comes up a lot in regard to somebody is home with the flu, and they're home with the flu for a week, 2 weeks. In this situation, how do you treat that? So it's got to be for incapacity for more than 3 consecutive days. Treatment 2 times by a healthcare provider. First in-person visit within 7 days, and then visits within 30 days. Treatment 1 time by a healthcare provider. Could be pregnancy. All this comes into continuing treatment for a healthcare provider. And as I indicated before, family medical leave can also contain or apply to chronic conditions. Any period of incapacity or treatment due to chronic health conditions, which is defined as a condition that requires periodic visits at least twice a year, continues over an extended period of time, or may cause episodic rather than continuing periods of incapacity. So again, all these are included in the definition of serious health condition. And it can include absence to receive multiple treatments, restoration surgery from an accident, for conditions that have untreated would likely result in incapacity of more than 3 days. The next question comes up is, well, how much time can that person take? And again, you're entitled to take up to 12 work weeks during a 12-month period. So up to 12 work weeks for birth of a child, care of a spouse, or for your own health condition. So again, it's not the employee that decides how much time they're going to take. It's you, from all the evidence that the employee presents, make a determination of what that period of time is. So it's up to 12 work weeks. Now, what is troublesome is the fact you can take it as blocks of time, or you can take intermittent, intermediate leave. And here, what this slide indicates, an employee is entitled to take intermittent leave and reduce schedule leave for a qualifying family member serious condition, service spouse, service member serious injury or illness, qualifying justice arising of the active duty status, or a leave to bond for a child, and it could be your own health condition. And then here, in calculating leave, the employer must use the shortest increment that the employer uses, and it cannot be greater than, provided it's not greater than 1 hour. And again, shortest increments may vary during different parts of the day. Required overtime not worked may count against this entitlement. So again, and this is, I think this is one area that many employers have trouble with. And the biggest problem with this is accounting for time, where somebody is accounted for 2 or 3 hours for medical visits, come back, and that person's a salaried employee, and how do you account for that? You know, do you have that person sign in and sign out? And that's where the biggest abuse is, right here, in making sure that person takes the right amount of time and doesn't overstay their welcome. So the special rules in regard to physical incapacity, in the sense of finding replacement employment, holidays, when are they considered, and especially if you're taking blocks of time, holidays are considered in those 12 weeks. If it's intermittent, it's not. And if when there's planned medical treatment, you have to plan around, so it's convenient for the employer. And in some situations, if that person has to work a reduced work schedule, they can be transferred temporarily to an alternative position. Now, if you have a married couple working for you, spouses may be limited for combined total for certain leave reasons, so you can limit that. Now, there's various ways of counting that year period, and that the method that you count that period of time is up to you. You can use a calendar year period. The only problem with a calendar year period is the fact you may have somebody that takes a certain period of time at the end of the calendar year, and then the next calendar year take another period. So they could butt up against 2 years and take 12 weeks in 2 years, because they are in 2 different calendar years. You can use any fixed 12-month period. You can, what's called a rolling period, where a 12-month period measured forward. So if somebody takes leave for the next 12 months, they can only take 12 weeks. Or rolling period, where it's measured backward. When somebody is asking for leave, you look back and see if they have any leave in their past, and then they can be granted leave if there isn't. So there's various ways, and then which you have to determine which one you're going to use in your circumstance. Now, another big question I've been getting is in regard to substitution of paid leave. Substitution means paid leave provided by the employer runs concurrently with unpaid leave, and it's again, the employees may choose or employers may require that person substitute accrued paid leave for unpaid leave, which includes vacation. So employee still remains entitled to unpaid leave if the requirements for paid leave are not met. So one way or the other, that person has to take leave. Now, one of the biggest issues and I think questions employers have in this situation is, how does this family medical leave works with various types of leave that you as an employer may offer? It includes workers' comp, disability leave, or any type of leave that the person's paid for. Well, in this situation, they work together in the sense that they're running concurrently. For workers' compensation leave, disability leave, it's really it counts against family medical leave entitlement. So again, they're working at the same time. You don't get additional leave. So somebody could be on workers' comp and also at the same time be on family medical leave. And remember, in this situation, somebody could be entitled to workers' comp but not be entitled to family medical leave. But again, in that situation, if somebody's not entitled to family medical leave, then the only way you can continue coverage in that situation, medical coverage in that situation, is, well, that person's on workers' comp, you have to put them on COBRA. If they're eligible for family and medical leave, then they're treated for benefit purposes as an active employee. So that's the advantage of that. But again, they work in unison with all this, and they are working together, and they're treated as you can be at workers' comp and family and medical leave at the same time. Okay, let's stop right here. Amanda, do we have any questions?
So the first one, we have a lot of our employees who use FMLA on an intermittent basis. However, as of January 1st, we are under 50 employees. As I understand it, we will be covered under FMLA until January 1st of next year. My question is, when we approve requests for FMLA leave for this year, will they automatically expire on December 31st? Should I write that expiration date on the designation notice? Thanks.
I would think you have to if you're no longer, I think since you're no longer going to be subject to family medical leave.
Okay. And then the other question is, on the previous screen, what was topping off referring to?
What that refers to, I think, is getting the larger leave. I think that's what they're referring to. The longer period of leave.
Okay. And then...
Any other questions? Mm-hmm.
Oh, if an employee exhausts their 12 weeks of FMLA allowance, what happens afterward?
Well, in that situation, if they don't come back, then you basically, in that situation, you have to, in order to continue coverage, you have to offer them COBRA. So at the end of their leave, and what's interesting here, I think, and I'm going to be talking about this the next few minutes, is the fact if, and this is where confusion comes in. Suppose you have, remember when somebody's on leave, your medical coverage continues. Everything continues as if, I mean, all medical coverage, medical, dental, and vision continues as if they're active. And they have to, and since they're not working, they will have to, if it's unpaid leave, they have to send in their payment. If they don't send in their payment, then there's a procedure where the coverage is ended. Now the question is, and many employers ask me this question, well, do they, at that point, do they qualify for COBRA? And the answer is no. The only in this situation, the only COBRA qualifying event is going to be the ending of the leave, and that's when you offer COBRA. So the person, if they don't pay their premium, and this should be emphasized, that coverage ends and they can't pick it up again until they come back or they go on COBRA. And that's the biggest issue and problem that some employers face when they offer family medical leave, is the fact that sometimes employees don't send in their payments, and you have to end the coverage.
Should the FMLA certification form also be completed if an employee is out on disability or workers' comp leave?
If you want to grant the rights under family medical leave, yes. And remember, it's a separate right. Just because you're on workers' comp doesn't necessarily mean you qualified. You could be there a very short period of time and you don't have the number of hours required. You haven't been there a year. So you're on workers' comp and you don't qualify. And remember, family medical leave is extremely important because for all intents and purposes, you have certain rights to have coverage for your family. So remember, workers' comp only covers medical coverage to treat your condition, to treat your injury, while family medical leave continues coverage for the entire family and general health for yourself. So that's why it's extremely important to, when somebody's on workers' comp, they have to, again, qualify under family medical leave to have general health coverage.
There you go. Does topping off refer to the leave, or does it refer to allowing another leave to be added to cover? For example, if disability only covers...
I think it's yes. I think adding other leave. That's correct.
Okay. If the employer does not charge the employees for benefits until they return from leave, how does this impact having to offer them COBRA if they do not return after 12 weeks?
Well, under certain conditions, you can ask for that money back if they don't return. So there's a procedure involved that you can, in certain circumstances, ask for that money back. So again, and that's why many employers don't want to do this, because of the fact if that person doesn't come back and you ask for the money back, you have to chase the employee. Mm-hmm. So that's one area some employers don't like doing. They rather either pay for the coverage up front or during a leave and not wait for that person to come back.
Okay, but does it have anything to do with offering them COBRA at the end of 12 weeks? Would that affect them?
No. You still have to offer them COBRA.
Okay. And based on what I'm hearing, I think we need to revise our FMLA policy. Where's the best place to go to get good information on what needs to be revised?
The best thing to do is go on the, and I have a bunch of websites at the end, and when you get a copy of these slides, you'll see them. But the Department of Labor has a lot of good resources in regard to family medical leave.
All right, and we may have some hands raised.
All of them are listed, so it's and I'll pause there at the end of the seminar just to go through all the resources.
Okay. There we go. We have one question. All right, Josephine, you're unmuted.
Josephine, are you there?
She has her hand raised, but is also inattentive, so we'll give it another second. And if not, we'll move on.
Okay, no problem.
Put their hand down. All right, so please continue.
Okay, no problem. Now, again, as I indicated earlier, employers have certain responsibilities. You have certain responsibilities to give a number of notices, a general notice and other notices when somebody tells you they want leave. You have to maintain group health coverage. That includes medical, dental, and vision, and also health FSAs. You have to restore the person to the same or equivalent job benefits when they come back. Now, it's not an automatic guarantee. If, for example, if their job is eliminated or they're gone because they would have been laid off, they don't have any greater rights, but they're not at a disadvantage if they go on leave. And then you have to maintain records in order to prove, one, you give them leave, two, when they're eligible for additional leave. So you have to, again, keep records to make sure that person gets their rights. So first of all, there's a general notice. under this, the employer must inform employees of family medical leave. You have to post a general notice or provide the general notice in the employee's handbook. If no handbook, distribute to the new employees upon hire. You can also electronically post it, have it on a website, but again, you have to be very, very careful in that because that person has to have access to a computer at work. Languages other than English required where a significant portion of the workforce is not literate in English. And if you don't give it, there's a penalty of $110 per employee that didn't get that if you're a willful posting violation. So again, this is something you should post in the break room or the lunchroom or whatever, indicating what their rights are under family and medical leave. And then when somebody does go on leave, there are two important notices that have to be given out within 5 days of that person indicating they want leave. First of all, there's a notice of eligibility where you indicate that to that person you requested leave and you are or not eligible for family medical leave. And again, it's up to you, the employer, to make that determination of whether that person's eligible. The employee doesn't ask for leave, doesn't ask for family medical leave. You have to tell the employee whether they're eligible or not. So again, eligibility determined on the first instance of leave for qualifying reason for the applicable 12-month. A new notice for subsequent reason if the eligibility status changes. You have to indicate to the employee in writing the reason for why they're not eligible, and this may be oral or in writing. I would, again, put it in writing if that person's eligible or not eligible. Now, at the same time that you give the notice of eligibility, there is the provide notice of rights and responsibility. And these numbers here, WH381 is the, again, if you go on the website, type that in, you'll get a DOL copy of this. And basically what this is, let me explain what this is. This tells the employee, all right, you're eligible for family medical leave, but in order to get it, you have to jump through certain hoops. You have to give us a certification, you have to do various things, and these are the terms that you're going to get leave. So again, the notice must include a statement that leave may be counted for family medical leave, the applicable 12-month period of entitlement, or what certification requirements, and that in that situation you have to give a medical certification within a certain period of time. What the substitution requirements are, you know, certain part of the leave is going to be unpaid, certain part of it's going to, all that's got to be spelled out. What's also going to be spelled out is the arrangements for premium payment. You have to pay for that coverage either before you leave, during leave, or when you come back. If you are a key employee, then you have to indicate you're a key employee, and what that means under certain circumstances, that employee, when they come back, may or may not get their job. And then if they're not so you have to tell the employee whether you are or not a key employee. And then indicate the fact they have job restoration and maintenance of benefit rights. So, you know, the fact that you're be treated as an active employee during a leave, and the fact that your benefits will be maintained as an active employee. But again, you have to indicate to the employee what the terms of the leave are and when payments are going to be, and what happens if they don't pay their, you know, when are the premiums due? What happens if they don't pay their premiums? All that's got to be stated in that. Then once you get all the material back, within 5 days of having enough information to determine leave is fine, so they return back all the material. Once for each qualifying reason applicable 12-month period includes designation, determination, substitution of paid leave, must be in writing. There's a form WH382. If the leave is determined not to be qualifying, notice must be in simple written statement. In fact, I'm sorry, you haven't complied with this requirement, and if you're going to take leave, it's not going to qualify as family medical leave. Employers must notify of the employee in this designation the amount of leave they're going to receive. If the amount of leave is unknown, the employer must inform employees of the amount of leave within 30 days. And in some situations, there can be retroactive designation, and this happens a lot when an employer forgets to do this. But again, you have to be very careful because that's only granted if it's seen that that person is not injured. So again, in regard to group health benefits, when they're on leave, they're treated as an active employee. So the same terms and conditions apply when they're on leave. So if your employees usually pay 20 or 30 or 40% of the premium, that's what it is. So it's completely different than COBRA. The employer must pay his or her share. And again, one thing, if the employee, they have right in the situation to say, no, I don't want coverage during my leave, but they have to be informed if you don't get coverage during your leave, you have a right to again pick up that that coverage once you come back. And again, in some circumstances, as I indicated before, the employee may be required to repay the employee share premium if the employee does not return, and that's got to be indicated when they go on leave. So again, employers can require employees to pay premium co-payments for group coverage. They can also require employees to reimburse employers for any group coverage premiums during the leave if they do not return to work from leave unless the employee does not return to work because of circumstances beyond their control. So there are some limitations for that requirement. If the employers terminate employees' coverage due to non-payment of premium co-payments, they must provide written notice to the employees 15 days in advance of the termination date. So if that, remember that employee has 30 days to pay for the coverage. If they don't pay it, you have to give them 15 days advance notice before that that coverage is terminated. Now, employees should understand that in that situation, they're not eligible for COBRA unless they tell the employer, I'm not coming back to work. If they tell the employer, I'm not coming back to work ever or during leave, what happens in that circumstance is the fact that the employee's leave is then deemed to be terminated. And when the leave is then deemed to be terminated, then COBRA can be offered. So here, job restoration, same or equivalent job, equivalent pay. The best way to remember this, they can't be disadvantaged just because you took family and medical leave. But remember, the employee doesn't have any greater rights to reinstatement than any other employee who continued to work. So if their division, if their job was eliminated when they went on leave, when they come back, I'm sorry, but your job isn't there. A bonus is predicated on specific goals, may be denied if goal is not met. And again, if that person is deemed to be a key employee, job restoration can be denied. So one thing I try to emphasize to employers that you cannot, again, discourage employers from taking or deny leave for employees, discriminate or retaliate against any person that does take leave, exercise their rights, discharge or any way discriminate against an employee because of their involvement in any family and medical leave, or use or take and taking a family and medical leave as any type of negative factor in making employment actions. That you cannot deny them a promotion or a bonus unless they haven't met the goals of that bonus. But again, you have to ignore the fact that person went on leave. So also what's important, you have to basically maintain records so you can support how much time that person took, basic payroll information, dates that family medical leave is taken, hours of leave if taken, if less than 1 day, copies of leave notices, documents describing benefits and policies, premium payments, records of disputes. So you basically have to defend yourself in case an employee indicates that their rights under family medical leave have been denied. So you have to, basically what this does, it helps support the employer's actions, the fact that I did follow all the rules. Here are all the things I did for the employee. And again, now here are the employee's responsibilities. And we just went through the employer responsibilities here. And again, if the employee does not satisfy all their responsibilities as I'm going through this, the employer can deny them family and medical leave. Doesn't mean they deny them leave, just the designation of as being eligible under family and medical leave, which means all the protections go by the way. And the only way that in this situation that coverage can continue if that person is offered COBRA. So, again, the employer must provide significant and timely, sufficient and timely notice of the need for leave. They must provide a certification to support the leave, provide periodic status reports, and provide a fitness for duty certification, especially if there's physical requirements for the job. Before they're let back into the employment, they may have to, again, and this has to be specified in the notices given to the employees that this is one of the requirements before they can, again, come back to work. That has to be completed by a doctor. So again, provide sufficient notice to make an employer aware of the need for leave, specifically reference the qualifying reason, consult with the employer regarding scheduling a planned medical treatment, comply with the employer's usual and customary procedures for requesting leave absent unusual circumstances. So if the employer has call-in requirements to call in for absences, you have to follow that as an employee. A timely timing of the employee's notice on need for leave. If it's foreseeable, they have to give 30 days notice. If the leave is unforeseeable because of an injury, you have to notify the employer as soon as practicable. But again, the employee still has to follow the leave requirements and notification requirements of the employer. So again, there's a medical certification, and this is a form that is in the DOL material. You have to submit it within 15 days. If the employer must identify any deficiency in writing and provide 7 days to cure, they haven't filled it out completely. And sometimes when you get these certifications back, it's completed by a doctor, and you can only decipher half of it. So you have to go back and the employee has to get a better copy so you can read it. In some situation, the annual certification may be required. And in this situation, the employee must provide that at their cost. And again, the employer, but not the employee's direct supervisor, may contact the healthcare provider. And this is the verify any information. This is the clarify any information. And in some situations, the employer can ask for a second or third opinion. If the employer questions the validity of the complete certification, the employer may ask for a second opinion. It's on their dime. If the first and second opinions differ, then the employer may require a third opinion. And again, that's on the employer's dime. So again, this certification is extremely important because it basically certifies the fact that the reason that person is taking leave, especially if it's a serious illness of the employee or one of their family members. And then recertification not more than every 30 days with an absence. And now if the absence, again, is more than 30 days, the employer must wait until the minimum duration expires. So if the doctor originally said that person is going to be ill for 2 months, then in that situation, you have to wait 2 months to get another certification. In all instances, may request every 6 months with an absence. More frequently than every 30 days if the employee requests an extension of leave, circumstances of certification change significantly, or the employer receives information that casts doubt on the reason for leave. So again, you have to document all this to make sure you ask for additional information. And again, fulfilling this requirement is extremely important, because if the employer doesn't satisfy this requirement, the employer can deny family and medical leave until that certification is received. So again, it's extremely important that the employer make sure that this requirement is fulfilled. Employer must respond to the employer's request to information about status and intent to return to work. And again, this fitness for duty certification, and again, especially if the job that person had has some physical conditions to it, the employer may have a uniformly applied policy practice of requiring fitness for duty certification for all similarly situated employees. If state or local law or collective bargaining is in place, it governs the return to work. Not permitted for increment or reduced schedule. It's going to be authorized and clarified. And the employer is responsible for providing this, especially if a medical certification is required for fitness for duty. So again, this is something that the employer can require. It's got to be in the notices provided to the employees, and so this is something that the employer can require to do. And again, for salaried employees, if they have a reduced schedule, certain deductions can be required even for exempt employees. So if they're taking 5 or 10 hours a week off for medical care, their salary can be reduced. Deductions for employees paid overtime on a fluctuating work schedule. And there's certain special rules for schools, especially when the leave is taken. The employer can deny leave, for example, if it's later in the year. They can also put limitations on intermittent leave. So there are special rules that apply to schools in that circumstances, limitations on when that person can take leave and how much leave they can take. So that's extremely important. Now in regard to medical military family leave, okay, here a qualifying leave which provides for up to 12 work weeks of family and medical. The health families manage the affairs of the military member have been deployed to a foreign country. And then secondly, 26 weeks if care for a person, service member that's been serious injury or illness. And again, all the family and medical rules apply in that circumstances. Employees eligible for take up to 12 weeks, and this is for a leave for a son, daughter that refers to a son or daughter of any age. The reason for the leave counts against the employee's normal 12 reasons for a 12-month period. This includes any active, covered active duty on a regular armed forces, or as this indicates, under the reserve requirements. And so this is, again, was really important for 6 or 7 years ago when we had a lot of troops in Afghanistan and Iraq, when the National Guard was called up, excuse me. This was extremely important. And these are the reasons, again, the qualifying reasons they can take a leave of short-term employment. You can take leave for military events or related activities, child care and school activities. And again, this is all related to deployment. Financial and legal reasons, that person is going to be leaving for 3 or 4 months, so you have to arrange all this. Non-medical counseling, care of a military member's parent, rest and recoupment up to 15 days. Post-deployment activities, it can be a 90-day period, or any additional activities by agreement between the parties. So these are all reasons when somebody's deployed, and because they're leaving, this is the reasons that can be used to take time off. So just like under family and medical leave, an employer may require appropriate certification. A copy of the military member's duty orders, qualifying certification, statement of facts, dates of leave, frequency of duration of leave, contact information. And again, all this can, just to verify if that reason is real. In addition to that, military caregiver, in that situation, that person can take up to 26 weeks. That's to care for a covered service member with a serious injury. This includes, again, a covered service member, spouse, parent, son or daughter, or next of kin. For a military care leave, son or daughter refers to the son or daughter of any age. And this leave is limited to a total of 26 weeks during a single 12-month period. And this includes a 12-week that normally applies for family medical leave. So these are all the various next of kin situation that can be used. You are a service member, it can be a spouse, parent, or son or daughter. Next of kin includes one blood relative, all blood relatives, all brothers and sisters, all grandparents. So again, in this situation, it can be the whole family can be involved in this. So again, a covered service member in this situation can be a current member or a veteran for this 26 weeks. A current service member includes members of the armed forces, including the National Guard. That includes any ongoing medical treatment, otherwise outpatient service, any kind of temporary disability can be included in this. Serious illness or injury is one that will occur by the service member in line of duty, existed before the service member's active duty, that was aggravated by the service, or it may cause the service member to be mentally unfit to perform the duties of his or her office, grade, or rank. So this includes a medical discharge. And if for 26 weeks of certification, a current member, employer may require leave to be for a covered service member to be supported by a certification. There's a form for that. Now this is very interesting because it also includes veterans. So a veteran of an armed service is a covered service member if he has ongoing medical treatment, recuperation, or therapy for serious injury or illness, was discharged under conditions other than dishonorable within a 5-year period before the employee first takes military caregiver leave. So again, this is somebody out of the service, a veteran. You can also take the leave for that purpose. So here, the illness or injury that occurred or aggravated by the service of line of duty that manifests itself before or after the service member became a veteran, that was either a continuation of the service, serious illness or injury that occurred or aggravated when the veteran was a member of the armed forces, a condition that which was a veteran has received a U.S. Department of Veterans a rating of 50% or greater, a condition that substantially impairs the veteran's ability to work because of a disability related to military service, or an injury that was the basis of the veteran's enrollment in the Department of Veterans Affairs Comprehensive Assistance. So again, there's certain limitations here. And again, in this situation, there's a certification. The employer may require a leave to care for a veteran to be supported by a certification. And again, there's a specific form for that you can have to fill out in this regard. Again, the application for leave is under a single 12-month period, is per covered service member per injury, and it's limited to 26 work weeks. So again, this is something that you may run into every once in a while. So again, if an employer is not complying with these rules, to enforce these rules, an employee may file a complaint with the Wage and Hour Division or file a private lawsuit. Action may be taken within 2 years after the last action in which the employer contends a violation occurred, 3 years if it's a willful violation. So again, an employer can be sued in this situation. There's a number of materials. Again, as I indicated before, there's the Employer's Guide for Family and Medical Leave, the Employee's Guide to Military Leave. There's family and medical leave forms, fact sheets, posters, frequently asked questions. And again, just go DOL, Family and Medical Leave, and all this material is really available. The DOL has done a really nice job in providing a lot of material for an employer to decide. And again, you don't have to reinvent the wheel in the forms. They provide forms for you. Are there any additional questions? We have just a few minutes left. I'm sorry I had to run through the last slides, but I just wanted to leave some time for questions.
Yeah.
Amanda, do we have any?
We have plenty. So just to confirm, when an employee returns from FMLA, does their effective start date begin on the day of their return or the first of the month following their return date?
The return date.
Okay, I had an employee who stated their mother was ill and that she needed to leave the country to visit her. I explained that if she was going to care for her seriously ill mother, I would need a doctor's note so that we could designate her leave as FMLA. However, she said that she was not the caretaker and she was only going to visit, therefore we placed her on a 30-day personal leave of absence. Is this practical?
You have to, again, in order for this, what you have to do in that situation, that person has to satisfy the certification. You have to certify that that mother is sick. So that certification has to be completed so the employer knows that's the reason why they're doing it.
But it says
that certification requires.
She said they placed her on a 30-day leave of absence instead. Is that practice allowable?
Well, again, give the employee the opportunity to comply. If they do not comply, you can deny the family medical leave and just give them a regular leave of absence. Correct.
Okay. But they wouldn't get the same protections.
Correct. Correct. Okay. I mean, in that situation, in order for health coverage to continue, they would have to be offered COBRA, and that person would pay for the entire premium.
Okay. If we have a pregnant employee who is unsure, she's still deciding if she is going to return to work. If she does not, can the employer recoup the premiums?
Yes.
If there are two separate FMLA events in a 12-month period, is it based on per event or per 12-month period?
Per 12-month period.
Okay. We would like to curb...
Are we starting the lightning round now?
Yeah, we're going really quick. We would like to curb abuse with intermittent FMLA leave. Is it permitted to contact a healthcare provider to confirm whether an employee has more treatment appointments or episodic flare-ups than is certified on the certification form?
You got to be real careful in that regard because there's all kinds of HIPAA issues and problems. I think you may want to go through the employee first because only under certain conditions can you. And let's see if I can find that. Bear with me a second. There was a slide that described that. Just bear with me. Here it is. Slide 35. The employer, not the employee's direct supervisor, may contact the healthcare provider to verify that the information is completed and authorized by the healthcare provider, clarify, understand handwriting or meaning of the response, and no additional information may be required beyond the required in the certification. So you got to be real careful in contacting the healthcare provider.
Yeah.
So I think what you want to do, if you want additional information, I think you have to request it from the employee, then the employee then contacts the healthcare provider. And if that information is complete after that, you request X, Y, and Z, they don't give you everything, then I think you can contact the healthcare provider.
Okay. Does an employee need to prove that they're the next of kin for military leave? If so, what is valid proof?
Oh, wow, that's a good question. And question is, how can you prove you're a cousin?
Yeah.
I don't know. That's a good question. I don't know the answer to that. I think probably the best thing is just do a statement saying, I hereby certify that I am the first I'm next to kin, and just go with that. I mean, how are you going to prove you're a cousin?
Okay. We had an employee injured on the job. She had one surgery and used almost all of her 12 weeks of FMLA, then had a second surgery and needs longer. Would this be considered a separate request for FMLA or included as part of the original request?
She gets 12 weeks in a 12-month period.
Okay.
So again, in that situation, if she took all her 12 weeks, then there's an issue and a problem.
Okay. And then, is there an amount of time that a person needs to return to work to qualify as returning to work?
I think you as an employer said when they have to return, you have to agree between you and the employee when they return to work. So when you basically set up the leave, you set the parameters when that person is going to return to work, and then you have to. And then if there's a fitness for duty requirement, that person cannot return to work until that person completes all the requirements that you've specified when they went on leave.
If the rules are not followed regarding FMLA, can the employee be terminated from employment?
They could be denied leave. I can't see why you would terminate them. I mean, what you would do in that situation, that person doesn't satisfy the rules, and you as an employee, as an employer, say, I'm sorry, you're not eligible for leave, you have to come back to work. If that person doesn't come back to work, then you fire them.
Okay.
So again, and what's important here is that, okay, that person, that employee requests leave. You as an employer say, you know, and you're going to be eligible for leave, and then you have to meet the requirements to get family and medical leave. If they don't meet those requirements for family and medical leave, then you as an employer have to decide, am I going to give that person leave of absence? You can set your own requirements for leave of absence. If that person doesn't meet those requirements and they leave work, then you can again terminate them.
Mm-hmm. All right, and then if an employee is on intermittent FMLA and the doctor does not specify on the certification how long the employee will need to be on intermittent FMLA, can we ask for a recertification?
Yes.
All right, and we have one more question, then I'm going to cut it off here because we're well past the end of our time. Our last question is, if an employee is unable to return to work after their FMLA has been exhausted and does not fall under the ADA, then can we terminate them?
Yes. And then you offer them COBRA.
All right. Clearly, we have
because remember the right to return to work is under family and medical leave opinion. Once your leave is gone, then your rights are then terminated.
Yeah. All right. Well, clearly we had a lot of questions, so not to worry. As I said before, you'll be receiving the link to this recording as well as to download the slides either this afternoon or early tomorrow. If you have further questions, you can always just email us. And Larry's contact information as well is at the end of the slides. He has a great...
just let me get that. Just bear with me a second.
You can sign up for his educational newsletter on his website, as well as if you're here, you most likely already received Benefit Expresses.
There it be.
Thank you, Larry. And we'll see you on February 7th.
Remember, on February 6th, February 7th, what I'm going to be talking about, and one of the things I'll be talking about is any action by the Trump administration to waive fees or penalties under ACA. So please, if you want an update of what's happening, just let me know. If you are receiving my newsletter, you'll get it probably as soon as anything happens. But again, we're going to cover that on February 7th.
All right. Well, thank you everybody so much, and we'll talk to you then.
Take care. Bye-bye.